Our topic today is Understanding Estate Planning, Key Concepts and Common Questions, presented by Alison Fleming, President at Lumena Financial Strategies. Alison is a certified financial planner practitioner, and for those of you who may be joining us for the first time, please allow me to introduce her. Alison has been a financial advisor since 1989 and serves clients in 29 states across the country. She holds a bachelor's degree in speech communication from Cal State Long Beach and believes that we must always adapt to the changing environment, remain current, and take advantage of opportunities to improve our clients' lives. Our local motto, "Be a long-term thinker, not a short-term worrier," serves as the cornerstone of her discussions.
Thank you so much. Welcome everybody to our webinar this afternoon. I was really happy when Caress told me that she had an opportunity where we didn't have another speaker lined up already, and been wanting to present this topic to you for quite some time. But before we launch into the material, let me go ahead and ask you to share our team slide, Caress, because that way everybody knows who they're talking to. So, of course, myself, we have Miles Fleming, our Executive Vice President, Insurance Specialist, particularly specializing in Medicare and Medicare Supplement Insurance. We have Brett Stevens, our Vice President, and Peter Fink, our Resident Stock Picker. We have Damian Feldman, our Client Experience Manager, who many of you have talked to when you're scheduling appointments. Terry Jocelyn, who's Executive Assistant and Administrative Manager here in the San Diego office for our practice here. And then we have Maddie Uoa, who is a Senior Administrative Assistant. And a little sneak peek, Maddie just passed her notary exam. So more to come. We're just waiting on the final approval from LPL to allow her to go ahead and offer that service up in our San Pedro location. And she's done all her swearing and all her, well, not swearing, but, sworn in, you know what I mean. And so she's going to be ready to go shortly for that service up in our San Pedro office. We have Kaylee Levin, who's our client care coordinator, and Lucy Adame, our administrative assistant, also in our San Pedro location. And finally, the voice from the sky, Caress Vera, our creative director, who has put together this whole presentation. And before we go into the slides, there you go. You've been fully disclosed. Now you have everything. Those are all the places. And I wanted to acknowledge Caress before we launch into the material here. She actually created all of these slides and she pulled together material. We worked quite a bit on it together, but she actually is the creative genius behind all of this material today. So I just wanted to acknowledge you, Caress, that you've done a fantastic job putting this together. So thank you. I really appreciate it. Everybody will really appreciate it. So why do you think that I would want to talk about estate planning? Because we're not estate planning lawyers. We don't do estate planning. We don't create estate plans. We can't give legal advice, but it's something that I run into every single day in discussions with clients. It's one of the most important questions that we ask. Even more important, I think, sometimes than risk tolerance is, what is your estate plan? Because it involves while you're alive and also when you're gone, and it's had such a big impact on families. So I thought it would be helpful to just put together some key concepts, common questions, not go too far into depth. And certainly if we wander over into legal advice, I will tell you that I don't know the answer. So first thing is, what are we going to cover today? So the first thing is the key concepts, what is estate planning? We'll touch a little bit about that. We'll go through some common terminology for estate planning and estate planning documents, and also some common misconceptions. We run into that a lot here as we're talking to clients about their estate plan, and they tell us one thing and then the document actually says something different. We also want you to understand what important roles there are within the estate planning documents and what the responsibilities actually are within an estate plan. Often I get asked, what does an executor do? What are my kids needing to expect? Things like that. It's really important. Common gaps and oversights in the estate plans. I think that's important for you to know as well. We threw a little something in there about turning 18 because I know all of you have people in your lives who are becoming young adults, whether it's kids, grandkids, neighbors, kids from the community, kids from your church. This is something that you can know and then pass along, hopefully, to these young ones so that they can get their stuff organized as quickly and efficiently as possible. And then some final thoughts and Q&A and a couple of new things coming up here too. So let's talk for a second about what estate planning is and isn't. So it's more than just a will. It's about instructions for your loved ones to make it easier later on down the road for them to help you or help each other. So if we just touch on a couple of these as we go around the wheel, healthcare decisions. It's very important to have instructions in place for healthcare decisions. We'll touch a little bit about that. Financial decisions, if you can't do it for yourself, whether you're out of town, whether you are in an accident or something else happens, authorizing someone else to make those decisions for you can really help as far as the management of the assets and cash flow during difficult times. Guardianship is one of the hardest questions. And I understand this because I now have 2 adult children, but they're recent adult children. And up until the time they turned 18, guardianship was a big deal. And I know in many families, that's one of your biggest questions, and people avoid getting the estate plans done because they can't decide on guardianship. So we can talk a little bit about that. And also for pets, we all have our fur children. Well, I do anyway. Asset distribution is what people think about mostly when they think about estate planning. It's all about the stuff or the money, but it's actually so much more than that. Beneficiaries are another concept within the estate plan, because you have beneficiaries whether you think you do or not. If you don't create your own estate plan, guess what? Your state that you live in has one already for you, and it may not be what you would want it to be. And then finally, legacy wishes. Many of our clients are charitably inclined. And so I think that it's wonderful to include charitable causes or community causes in your estate plan, in your thinking. So it really helps you plan for what's unexpected things or perhaps expected things. Make your wishes known, protect the people that you care about, and create clarity and reducing stress. I think that it's the families that have these estate plans put together tend to have an easier time when the unexpected happens than those that don't. So we can go into that a little bit more. And it really doesn't mean you have to be old to create an estate plan. So turning 18, this concept was actually the genesis of our financial literacy hub that Caress has created on our website. There was a document that she found that had all the rules about what you need to worry about when you turn 18. Your responsibilities when you're driving, your responsibilities out in the world, what you can do now or can't do now, or if you did do and got in trouble for it, it really matters. Whereas if you're a child, certain things you can do, you can get in trouble for it and you're given a pass. So I think it's definitely important from that standpoint to have a good knowledge of it. Marriage is another opportunity, and I think I would put divorce in that same bucket, because marital changes, shall we say, it really matters that you have what you need in place so that you protect your current family and current wishes. Your kids, when my kids were minors, and my youngest just turned 20, and when my kids were minors, we wanted to make sure that the right people would be raising them if something were to happen to us. It's really, really important to name at least who you want in your family. And again, it's a difficult conversation sometimes, but it's worth having. Home ownership is another sort of a planning opportunity. If you buy or sell a home, your assets or liabilities may increase or decrease depending on what you do. And what we often find is people forget to put their new property into their trust, or they forget when they do a refi or something like that, they forget that it's got taken out along the way and they need to put it back. So there's something to think about there as well. Business ownership. Some of you own businesses or know people who own businesses. That is an estate planning opportunity for sure. Retirement, as far as that stage of your life where things are changing. Maybe your beneficiary designations need to be a little bit different now. Maybe your healthcare wishes are a little bit different now. Maybe your long-term care planning becomes more relevant to you as you start thinking about retirement and moving forward. Blended families are always an interesting opportunity, his, hers, and theirs. And different families have dynamics along those lines where if you don't have the plan in place, things don't always go as you wish they would. And then finally, aging parents. Many of you may have those folks in your life as well. The estate plan to support your parents. It's their estate plan, but it's also your estate plan too. Many of you may know, and I see some clients here on the line who would know this, but last year, my mom passed away just a little over a year ago. And so a lot of these concepts I'm talking to you about are really from my personal experience. We were very, very, very fortunate that my parents did their estate planning. And when my dad passed a few years ago, everything went smoothly. And then when my mom passed, my brother and I knew exactly what her wishes were, and we had talked about it all ahead of time. So we had no problems, no issues. And we were really in lockstep as far as how things would go. It really took a burden off as far as our having to think about it or deal with it at the time of the stressful time. So I would just encourage everybody to really pay attention to where you fall on this continuum at this moment. So let's talk a little bit about common estate planning documents and what they do and what they are. So the will is for your stuff. It's for your stuff if you don't have a trust. So a will, what's the difference? A will goes through probate. It gives instructions on what you want who you want to have your stuff, or who you want to give certain amounts of money to, or grandma's diamond ring or whatever, but it does not avoid this probate process. And so probate is the state's estate plan for you if you don't have anything else. Every state is different. And I know we've got clients on the line here from all over the country right now. I can see at least 3 different states represented, and every single probate is different. So the estate planning documents you need are very state specific. In California, probate is expensive and it takes a really long time. In Texas, I've learned from clients, it's like 6 weeks and it doesn't really cost that much. So maybe you'd have a different opinion about whether you do a trust or not if you were in California versus if you were in Texas, for example. So the trust holds non-retirement assets. Retirement assets are a separate thing, and we can talk about that in a minute. Power of attorney is in effect when you're alive. So a will is for when you're gone. Power of attorney is for when you're still here. And so there's a financial power of attorney, and then there's a medical power of attorney. So the financial power of attorney basically says who can speak for you in terms of the finances, pay the bills, make investment changes and things like that, if you're not able to do it on your own, or sometimes even when you are. We'll talk about that too. Healthcare directive or medical power of attorney basically gives your instructions or your wishes as far as life support or not, if you're resuscitated or not, if you're an organ donor or not. All those kinds of things can be addressed in the healthcare directive. And then a pour over will is often part of a living trust, but it is a separate document within there that basically says, whatever I forgot to put in my trust, I didn't mean to forget it, throw it on over into the trust because I meant to put it in there, I just forgot, basically. So they're all working together in context of your entire estate plan. So one of the things that I wanted to point out, that little light bulb down on the bottom, that a will doesn't automatically cover incapacity planning. The power of attorney and the healthcare directive cover that piece of it. So let's talk a little bit about a will and what that does and doesn't do. So it names your beneficiaries, who's going to get your stuff. It can name guardians for minor children or pets. It appoints an executor, And so the executor is the person responsible for taking that document to the court, filing it, and doing all the stuff as far as notifications and things like that, paying your debts, whatever it might be. It is subject to probate, which, like I said, is that process that you go through with the court. But it does provide hopefully clear instructions on what you want so that it is more clear as you go along. So the first thing is you create the will when you're alive. It names your beneficiaries, identifies your executor. When you die, it goes to probate. The probate process begins, and the executor is managing the estate. They have to gather up all the assets. They have to get valuations. They have to do whatever it is the court is requiring them to do. They have to file the documents with the court. And I will make note, that's not a private process. It's a public process. So before the assets are distributed to the heirs, creditors can come and make claims. And as long as there's back and forth and disagreements going on and the court hasn't closed out the probate, this can go on for years. So a couple of notable examples that have been in the news is some of you are old enough to remember Elvis. Elvis had a will. He didn't have a trust. His estate went to probate. It took literally years and years and years. More recently, Prince is one that's been in the news as well. And it's been literally years for him as well. Famous people who definitely had the resources who didn't do it. So I would encourage you to be one of those people that takes care of things appropriately and doesn't just leave it up to the probate court to have people fight it out. So living trusts are the next document that I just kind of wanted to touch on. And again, I am not a lawyer. I can't tell you what the right document is to have or not, but it depends on your goals. It depends on your circumstances, your state laws. I would encourage you, if you have a question, to talk to legal professionals in your area about it. We can give information, we can do planning, we can do modeling, but we can't draft the documents. We can't be your lawyer. So the living trust, though, I'll just call out that it is a living document. So a living trust provides you peace of mind because it creates a private experience for your family. You don't go to court, you don't fight it out. My mom had a trust. We didn't have to do anything except for my brother and I were the co-trustees on it after she died. And it said certain things. We just followed the rules. No harm, no foul. Nobody had to know anything about it. One thing that you may not know about me is I have a half sister from my dad's prior marriage. She's a very nice woman. She's considerably older than I am. I don't really know her that well because she didn't live anywhere near us, and we've been in touch over the years. And you know, she's super nice, but I don't really know her very well. And there was a provision in my parents' estate document that was to give her a set amount of money when my dad passed away. Well, my mom could have waited to give it to her, technically. She chose to give it to her when my dad passed away, and my half sister was absolutely flabbergasted to receive this gift. But then our responsibility was done as far as what we owed to her for my parents' wishes. When my mom died, my half sister had already been taken care of through that process, through their living trust, because it gave those instructions specifically in there that she's to get a certain amount of money, and okay, that's fine. It bypassed probate, so there was nothing that anybody could do to come and try to weasel their way into the estate. It can provide ongoing management. So we call that controlling from beyond the grave. So there are living trusts which can actually keep going after someone is gone, because it creates other documents that spring up upon death. So whether it's special needs kids, whether it is beneficiaries, minor children, specifically documents can pop up out of these living trusts as needed at a later date. They're very flexible. You can pretty much write in almost anything you want, and also changeable because there are two different types. So revocable trusts are what we normally see if somebody just does a regular old living trust for a family. Irrevocable trusts are somewhat seen every now and then, not very frequently, but they do get created upon the passing of people from the revocable trust. So we'll talk about that next. So revocable versus irrevocable. Difference is control and flexibility. So my revocable trust can be completely changed at any time in my lifetime. Use my mom again as an example. So when my parents were both alive, they were able to change it anywhere along the way. When my dad passed, it became my mom's. She was able to change it anywhere along the way. As she got older, her eyesight started getting worse and she had her marbles. She had capacity 100%, but she couldn't see stuff and she had a bad tremor. So she asked my brother and I to take over as co-trustees along with her, which meant she could add us on because it was revocable. She could do anything she wanted to. We could not, as a co-trustee, do that, but she could do it. Once she passed, as the last grantor of the original trust, now all of a sudden it became irrevocable. My brother and I couldn't change anything about it. If we said, well, we wanted to, split it up differently or do something like that, the successor trustee in this case was the two of us together because we got along, but many clients' families don't get along as well, or there's one person who's more suited for doing the financial piece. Maybe another person is more suited for doing the medical piece. So once something is irrevocable, it can't be changed. You just have to follow the trust. So some people have in the past created irrevocable trusts, mainly when the state tax laws were different and used to only get to pass along 600,000 to your heirs. When I actually started back in the day, it was 200,000. Then it went up to 600,000 and it gradually grew and grew until now most people, it doesn't even matter because each person can pass along like $15 million or some crazy number. So most of us are not in that position to be able to pass along that much money. We don't really have to worry about estate taxes anymore. So the next type of document is a power of attorney. So there's two kinds. Financial power of attorney, which is the financial decision makers, can pay bills and expenses, can buy and sell property, business and legal affairs. Medical power of attorney makes medical decisions, treatment decisions, communicates with doctors, makes end-of-life decisions if necessary. And they can be different people. So, like I said, sometimes it's more makes more sense to have one in charge of the finances, one in charge of the healthcare. And I'd like to point out down at the bottom something that is really important to know is that you have both types, and they can be two different ways. So one of the common things that we see come through our office is power of attorney for finance that is incapacity only. They can be written as durable, which means they're in effect now. Incapacity only won't work until a doctor actually writes it in a letter that you don't have capacity anymore. So we'll touch a little bit more on that as well. And I would just say, pick people that you trust, pick people who think along the lines of what you would do, and who will listen to your wishes when you're talking about the power of attorney and healthcare powers. So next would be a little bit deeper dive into healthcare directives. One of the most stressful times for clients and families really is when a loved one is in distress. And it's really hard to know what someone really wants unless they've said it in a document. And it's we've seen more than once where clients have come in and said, well, my brother thinks this and my sister thinks that, and I think my mom really wants this. And I can't weigh in on that. It's really a family decision. So if mom expressed their wishes, that was important. Again, going back to my mom, she was adamant about no feeding tube. No matter what, no feeding tube. That was her wish. So I had to respect that, even though it was quite difficult at that time. That was what she said in her documents. That was what she said over and over. That was it. That was her call. And so it really made me feel and my brother feel like we did the very best we could to respect her wishes and help her through the difficult transitions. So I think it really does reduce stress and uncertainty to know that you're doing really what's in your loved one's best interest from their perspective, right? Myth versus reality. So often we hear estate planning is only for the wealthy. It's not. The reality is it's for everybody. So parents of young children, homeowners, young adults, blended families, individuals who have an opinion about anything, an estate plan is important because you have an estate, whether you have a lot of money or not, you still have an estate and you have yourself. So I really feel like it's all walks of life and it doesn't have to be all that expensive and it doesn't have to be all that complicated. So that was our next topic was it's so expensive. It'll take a lot of time. It's only for people with a lot of money. It's overwhelming. And I have had clients that have actually said, you know, I got quoted $7,500 for a trust and it's just me and my son. I don't know, you know, why I need to do that. Well, there are options out there. And also I've had clients who have said, you know what, I don't want to have to set a bunch of appointments with a lawyer and go meet with this stranger basically and share all my family business with this person. Other people realize that, you know, at the end of the day, even though it may be effort on the front end, on the back end, when the time comes, it really saves a lot of time and a lot of money and a lot of stress because even though it may cost some money to set it up, the probate process, at least in California, is expensive. And it can be a couple $1,000s on the front end versus a couple $100,000 on the back end. So, you know, again, it's up to you, but it doesn't have to be all that complicated. I hear sometimes clients say, my family already knows what I want. All my kids agree. Everybody knows what it's going to be. Okay, that's good. However, what happens if someone changes their mind? What happens if when the rubber meets the road, someone really isn't on board with the ideas as much as you thought? And also what happens if what you want to do isn't actually what the documents are going to tell them to do? So I've had situations where clients have said, well, you know what? I want to split up my account between my 3 kids, but my oldest is really the most responsible. So I'm going to give it to them and they're going to give it to their siblings. And they've promised me they will. So I'll just leave it to you to think about how well do you think that always works out? So much better if you have the conversations, and also even better if you have the documentation to back up the conversations. Another misconception, I don't own much, so I don't need an estate plan. I think we've already established that you do. Even if you don't have a lot of stuff, even if you rent, an estate plan isn't all about your stuff. It's all about you and your wishes and making sure that everything is as it should be. So let's talk a little bit about roles within the estate plan. So you're the maker of the estate plan, as known sometimes as the grantor of the estate plan. So you're the person making it up. So these people are other people involved in your estate plan. So beneficiaries, people or organizations that get your stuff, whether it's retirement plans, which name beneficiaries directly, or annuities, which also name beneficiaries directly, or beneficiaries of a trust or beneficiaries of a will. They're the people or the places that get your stuff or your accounts or your assets. Trustee is the person or institution responsible for managing and administering the trust when the grantor is alive. So if my mom is still alive, she's the trustee. She can name me as a co-trustee, but while she's alive, she is in charge. When she passed away, my brother and I became successor trustees. That means we're now responsible for activating the wishes of our mom and distributing it, but that role doesn't take effect until the person's gone. So I've had clients walk in with the document and say, I'm the successor trustee on this document. I'd like to make some changes on my parents' account. You can't. You can only do it if you're a trustee or if they're gone. As a successor trustee, it's only effective when they're gone. Executor is more about the will. It's just following the instructions. And then there's professional fiduciaries are often discussed as sort of a backstop. You may not have family members that you can count on to do this job. You may have no kids. You may have a small family. If you don't have someone that you want to be responsible, or if you just think it's too much of a burden for those people, there are professional licensed bonded fiduciaries that you can hire to be your person when you are gone or when you need help. So they're local, they're licensed, they're bonded, they're reputable. And, there are many different types of professional fiduciaries. So the fiduciary responsibility is that they have to act on your best interest, as does a trustee, if it's someone who is the trustee when you're still alive. So making sure you get the right people in the right seats on the bus is really, 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 really important. So different roles, different responsibilities. The executor is the estate administration. The trustee manages the trust assets. So it's somewhat the same when it comes to the final action, but they are different. And again, you got to pick the right people, right? So next slide. Here's things to think about when you're thinking and considering who you want to name as your person or people. Are they organized? Can they keep track of stuff? Do they communicate clearly, work well with others? Do they have the time and flexibility to fill in that space for you? Are they willing to take on that level of responsibility? And can they act in a prudent manner to take care of business in an appropriate way? There just isn't a perfect person, but you can get as close as you can get. Also, I would encourage you to name multiple layers of people, not just one, because if that person is fine now, but 20 years down the road, they're still named in your document, and now they're, older, or maybe they're not around anymore, you don't have a backup, that's when you run into trouble. So it's always good to have at least two, and better to have three if you have the people. So here's where we run into stuff, gaps that we see all the time. Outdated documents. If somebody has a power of attorney that's over 5 years old, we're actually required to get another form signed that says it's still effective as it stands. LPL has a form that we get you to sign. Missing beneficiary updates. There are some interesting outcomes that we've seen when people have forgotten to update their beneficiaries. People get divorced, people die, people get married, people move out of the country, people have issues. And it's really important, both in your legal documents and also your beneficiary designations, to make sure those are up to date, which is why every time we meet with you, we run through your beneficiaries. Every single meeting prep, we look and see what it looks like, and we check to make sure it's still the same. So incorrect titling, improper ownership of assets, like, for example, you refied your house, you took your house out of the trust, forgot to put it back in the trust. It causes delays, it causes some cost. And that's unfunded trust too. If you just make the document, but you don't actually put your assets in it, then it's just a document. The assets are still outside. Even if you list them in the document, they're not in until you actually title them in there. And then successors, we talked a little bit about that. We often have people come in and present a power of attorney document that's incapacity only. So we submit that to home office, And if there is no incapacity, it will not work. So from a practical standpoint, durable power of attorney is the person can act on your behalf at any time. So my husband and I have this, right? I trust him, he trusts me. He can act on my behalf on any of my accounts at any time, no harm, no foul, no problem, and vice versa. If it was incapacity only, something happened to me, he would have to get a letter from the doctor, or sometimes it says 2 doctors. And what do you think the chances are of getting 2 doctors to state you're incapacitated with today's healthcare environment? It's not easy to do. So if I'm not incapacitated, maybe I'm just out of the country on business and something needs to get done. If it's incapacity only, he can't do it. So on the flip side, though, sometimes people have their kids as their power of attorney. They don't want their kids being able to act unless they're incapacitated. So there really isn't one right way to do it. It's just knowing the difference between them, if that makes sense. So trust funding, creating your trust, retitling it, and then ongoing review. That's the most important thing, is to make sure that you fund it correctly once it's created, often a gap. And then there are situations where power of attorney may not apply. So there are some institution specific requirements. For example, Bank of America would not take my mom's POA. They had their own document that they made her go sign in the bank because it was institution specific. Outdated forms, if it doesn't meet the current law, it may not work. If it's too very old, it may not work. And every state has its own document. So if you moved, it may not work. Timing limitations, power of attorney may not be effective when you need it to be effective. So just to be careful about really being thoughtful about that. Capacity concerns. If someone lacks capacity, they can't sign stuff. So if there are capacity concerns and someone turns in a power of attorney that is recently signed, it may not be accepted by whatever institution because of the concern that they may or may not have been able to sign. Now, I have been in meetings with clients with their attorney where, maybe there's a dementia case where you've just been recently diagnosed, but you still really have capacity for quite some time. You still are able to sign documents with say, an Alzheimer's diagnosis. If the lawyer's determining that, you do have, you have capacity, you've got the disease, but you still can make decisions, you still are not unable to sign documents, but there does come a time where you can't. And then living trust assets, that's another gap we run into, or a situation where someone has a living trust account. They present the power of attorney and it's all good and all fine, but it may only apply to, say, retirement assets because the power of attorney is not written specifically to cover living trust assets. That would be the trustee, the co-trustee, the successor trustee that would step into that role. So the best thing to do is just make sure your stuff is up to date. One of the things we run into is ex-spouses still being named on documents as the beneficiary. We don't run into that as much as we used to, but it still does happen in the case of an ex-spouse being named. New spouse can't come in and claim those assets. It's on the form. It's the ex. Probably want to make sure that's not happening in your case if this is a concern. The next case study is, that's not an actual picture of my son, but it could be, where somebody away at college had an accident. Something happened and couldn't communicate medical preferences, or maybe didn't have medical preferences because they're too young. They don't really think about these things. And the parents couldn't make legal decisions for that person without that directive on file. So very, very important. 18. Medical privacy laws, depending on your state, are at different rules at different ages. For sure, it's 18. California is a little ridiculous. Sometimes things are age 12 or age 16 or age 18. Different states are different, but that is definitely a concern for parents who have kids that are turning 18. Financial access limitations. Even if you have a custodial account for your kid, 18 or 21, depending on your state, is when the parents no longer have any say-so over what happens in those accounts. And then decision-making authority, when somebody turns 18, as long as they have capacity, they're able to make their own decisions. Much as you would like to maintain control, it really is very difficult. So what can you help your young kids with? Considerations, emergency contacts, making sure that you know who those people are, what are their healthcare wishes, help them with budgeting, and important document storage. What do they need to actually keep track of? Because I don't know about you guys, but my kids don't keep track of anything, not even their laundry. So never mind the documents. We do have an area on our financial literacy hub that we will touch on at another time, that really has a whole section about young adults and turning 18 and all the things that are listed on this slide. So takeaways: estate planning is ongoing. It should reflect your current wishes. Communication and documentation both matter, and small updates make meaningful differences. Also, professional guidance can help coordinate planning. So, couple things before I let you go. We have now access to a new technology called wealth.com. We are not estate planning attorneys. We can't design and give you advice on your legal documents, but we now have access to an online estate plan building tool as part of our financial planning suite of offerings. So it's not a one size fits all. You don't say, I want to trust, I want to will, or whatever. It actually walks you through a questionnaire which says, here, what are your concerns? Click, click, click. And it says, based on your state and based on your answers, here's what is recommended in your case. And so it's like a document wizard, and it helps create documents or restate documents for people that are interested now as part of our financial planning tools that we have. So one of the things that I love about wealth.com is this tool that they have called Esther, where if you have documents already, we can scan them into the program, and Esther will actually read. It is an AI tool. It'll read your document, and it gives an estate executive summary. It can do an advanced executive summary, and it also has insights that pull out references to your documents to say, hey, this might be something to take a look at, or this box wasn't checked, or did you know that it's in capacity only when you thought it wasn't? So it's been a really, it's a new tool. We've just started working with it in the last 60 days or so, but I really like what I'm seeing so far. And so I wanted to just offer up to anybody who's here on the call, if you wanted us to run your estate plan through Esther, we'd be happy to do that and see what comes out. Before I have you do that, though, I want to call out one thing to be careful about. If you missed our June webinar, I would ask you to do the replay, which is on our website, because it was all about cyber awareness. And there's a handout that Caress can send to you upon request that basically talks about security. Because what I don't want is anybody on this call to just randomly scan your entire estate plan and email it to me in an unsecure way. I would like to ask you to either upload it to your portal, or you can send me a flash drive, or we can send you a secure link where you can upload it if you have it digitally. If you live in town near either one of our offices and you don't have it digitally, you can stop by and we will scan it for you and give you back your originals. Just please make sure that you don't just randomly send it out there into the world. And that is my little security update. So let's talk about one other thing, sneak peek, coming soon. We have a new and improved website experience for you. It's going to be looking like that. It's a great fresh look. It's a lot easier to navigate. Caress, do you want to chime in on this? I know you've been the mastermind behind the project as well. Uh,
Sure. Yeah, we're
yeah,
very excited. It literally hours fresh. It
yeah.
just was published an hour before we started. So it is still under, there's some things they have to do in the background. So if you're clicking on, for example, if you try to go to the events page right now, you'll just go right back to the homepage. So just forgive us and thank you for your patience while we're fixing those things. But once it's all working, we're going to send out an email to let you know it's time to come and take a look. It definitely has a beautiful new refresh face. So it's much more modern, new, beautiful images. So it looks pretty, which I always like. But also the most important part is it easy to navigate? And that is a
Yeah.
yes. It is, you're not going to have to go looking for things. You'll still be able to find things where they were. So it is easy to access. Account access is still there. That's where you can find the trusted links to all of the providers we work with and client works, all of those things are there. And then under resources, we have the same things you're used to there. The events and webinars page will be there. And there's a new page, which is a FAQ page, and it's just frequently asked questions. That'll serve our clients as well, but also I think it's more so for those who don't know who we are and don't know what we do. So that's a good place if you have friends who have questions. The answers are probably in there. So that's a really fun new addition to the site. And then the Financial Literacy Hub is still also in there, helpful links, tax resources. Those are all available under that resources button at the very top. So yeah, that, and we also added our new San Pedro location, though, as Allison said, our primary location is in San Diego. Allison and Britt do meet with clients in San Pedro, and so we have the address and directions there as well. So that'll be under the contact us. But yeah, we're really excited. It took months and months of work.
A lot of work, absolutely.
Yeah.
Well, what about YouTube?
Oh, yes, and on YouTube. So on this page, I can't show you just yet, but on the page, we have published our videos to YouTube, and that is because on the events page, normally what you'll see is that we only keep a year's worth of webinars that we've done. So if there was something from, more than a year ago that you really liked, which we do have some, I mean, Chris Scott does some fabulous year-end, dinner planning, and he's done makeup and skincare for us. Those will now have a home to live in, so you can still watch those. And then you'll have another place where you can get notified when a new video is uploaded. So once that's live, we'll also announce that the videos are there, but we are going through an approval process and all that fun compliance stuff we do. And so yeah, we'll be sending an announcement for the YouTube, but we're excited to announce that that's coming. And there's some fun stuff coming to that YouTube too. So
Yeah,
closer to the year, end of the year.
lots of new stuff coming. So
Lots of new stuff. Yeah.
hopefully you like that. And again, I'd like to just acknowledge Caress for having been the brains behind the operation in terms of the website refresh. I think it's time, and I think she's really done a great job in spearheading that project. So
Thank
thank you so much for doing that.
you.
With that, I would like you to save the date. It's going to be the 22nd of July. It's going to be a Wednesday. More to come on the topic because we can't tell you what it is until we've got the approval for the invitation. So it's going to be great. You're going to love it. Just save the date and more to come. And with that, I would like you to thank you for joining us this Wednesday afternoon. Really appreciate your time. Hopefully you have learned something new. And again, if you want to have us take a look at your stuff, then more than happy to do that. Just make sure that you request a secure link or let us know when you upload something to your portal. Have a great rest of your evening. Thank you so much. Have a good one.